Well, thanks for inviting me to speak again. I thought I'd go over kind of current events that are going on at the division, things that we see kind of outside of enforcement, and then go into the common complaints that we see through the investigations process. I cannot tell you how much we've learned in the past couple weeks how non-conducive state employees are to change in IT systems. I had a little issue this morning with even our car checkout system. So if you're trying to reach anybody down at the division via email, I'll let you know we are transitioning from Outlook over into Google. This has been an ugly transition process. I'm pretty sure at some point somebody in real estate is going to take somebody else out in one of the other state agencies at this point. So if you're trying to email somebody and you're doing it at the dora.state.co.us, the addresses have changed. There's no more Dora in it. It's just at state.co.us. And God forbid if you're one of those unfortunate people going through one of our CE audits right now, the email boxes set up for you to basically scan those documents and email them to us are not functioning. So yeah, we're living the high life right now down at the Division of Real Estate. So if you're a broker undergoing one of these audits, meaning real estate broker or mortgage broker, call in to the 2166 number and they will route you to somebody that's doing one of those audits. Chances are for the real estate brokers it's going to be Linda or Lynn. If you're an appraiser undergoing one of these audits, please email your certificates to me at marcia.waters@state.co.us and I will take care of it. We're doing that because I guess when you're the division director, you get to have the largest email box in the division. So that's one of the perks of the job, apparently. But we also want to make sure that the appraisers, we're handling their CE audits, because if they don't get their documents to us, they're not going to be able to renew, and we don't want to impede that process anymore. So bear with us. We're also not able to send out any blast emails. Supposedly that functionality should be coming up this afternoon. So we're going to send out a couple test ones, and we have our fingers crossed that it's actually going to work. We would have emailed everybody about the issues with the CE audits, but that's when we found out that we can't do blast emails. So fun times. And you'll also notice that we have a new website. I've heard some good feedback from the licensees about the website. I can tell you, I'm glad to hear it's user-friendly for you, because there's a lot of cursing going on internally. We can't find anything that we need, so bear with us if you call in and it involves any email or website searching on the behalf of staff. One of the things that's coming up for all of the brokers and the appraisers is fee setting. We try to get those fees set by November 15th. I'm not sure if we're going to be able to hit that deadline. The executive director is playing an active role in fee setting at this point. We just set mortgage broker fees. Those went up a little bit. One of the changes that we're doing with the fee setting process is we're not going to send out an email blast, even if we have functionality, letting everybody know that the fees have changed. This just elicits verbal abuse on our part, and we'd like to have pleasant thoughts of our licensees. So once they're finalized, we'll post them to the website. They'll be available. But our goal for your guys' fees is November 15th. So if you're curious what they are, that's the day to check. Forms have been finalized as of last week. There's going to be 18 forms that have changed. There's one new form. It's the green addendum. What you'll see with some of the forms changes is the contract to buy and sell now affords the buyer and seller to negotiate title. Closing instructions are now optional. That we were kind of beating a dead horse because the Division of Insurance imposes requirements on title companies about closing instructions, and for us to say that you've got to have them at the time that the contract's signed and everything's delivered doesn't necessarily work for the title companies. So if you are compelled to complete the closing instructions, you can do that. You can have the title companies do it and just get a copy of theirs. Either way, you need to make sure that they get done by somebody, but they are optional. It's no longer mandatory for the brokers. There's going to be a legend on the inspection notice that basically says it's the buyer's responsibility to forward those documents onto their lender. This is due to issues that we've been seeing as far as when you guys have been trying to negotiate inspection items and the lenders are telling you they don't want to see it for whatever reason that they're doing that. We get concerned when they're telling you to misrepresent things, because if they're telling you to lie about something, potentially they're asking you to help them commit mortgage fraud. So we don't want you to do that. But so there's a legend now on the inspection notice. The resolution is now a separate document, and this will hopefully help you guys kind of maneuver those issues as you go through your transactions. One of the things that we're going to be looking at is just kind of the whole forms process, how they're changed, what gets changed, and that's something that actually the deputy director is going to be working on tomorrow and Thursday with a smaller kind of subcommittee of the forms committee to really kind of hammer out what we need to be doing and increase efficiencies with that process, because it is not efficient if we are doing 30 some odd forms changes every year and you guys are having to relearn the process or relearn the contract. So that is kind of one of the goals, is to make the process more efficient. We also totally lost my train of thought on that one. Oh, the goal eventually is to make kind of a plain language contract so that those documents are understandable to consumers along with the brokers and the attorneys, because we do get a lot of calls when people have been abandoned by their brokers, and it's not our position to be able to kind of walk somebody through a real estate contract. We don't want to provide legal advice at the division level, but we want consumers to be able to lift up that document and understand what it says. So that's going to be kind of one of the goals in the upcoming year with the Forms Committee. Some of the other things that you've seen changing are we've been doing some rule revisions and also some position statement revisions. And just to kind of give you guys some information about the difference between the two, rules are regs, and those are something that the commission can discipline your license if you don't comply with them. Position statements are simply to provide you guidance. They don't carry the force of law. You're not going to see anybody that's, disciplined for violating CP2 or CP20. But a lot of the time we use those position statements just to kind of explain what the regulator's mindset is in the application of rules and laws. So on that note, recently the commission revised CP20, which is the position statement on personal assistance, and it's really to provide clarification about, E&O issues when you're dealing with personal assistance, compensation. For whatever reason, the old position statement kind of defined how you had to pay your personal assistance. I really don't think that's the commission's role, is to tell you how to pay your employees. So that was changed as well. One of the other concerns was that sellers may not be aware that, a buyer's agent may use a personal assistant who's going to access the property instead of the licensee. So the position statement will hopefully better address that scenario as well. We also revised CP34, which is the position statement on closing instructions, and CP2, which addresses earned fees by brokers, and that will provide you some guidance on kind of the Real Estate Commission's perspective about administrative fees that are charged by brokerages. Basically, it's their take that they don't have an issue with it. Bear in mind, though, that the commission doesn't enforce RESPA, that is the Consumer Finance Protection Bureau. But as we go in and do audits, if we're seeing that a brokerage is charging an admin fee, one of the things that the commission is required to do is, if they see a law violation, whether it's criminal code, civil issues, whoever the appropriate law enforcement authority is to address those issues, they're required to refer it on. And we felt that it was important to kind of make that distinction so that if we see a brokerage fee, you know that we're not going to be referring it on to CFPB based on the commission's take on that. Because I anticipate we will see that. We are going out and doing audits, and hopefully they are helpful to all of you. We revised a few rules over the year. One of the recent ones was Rule B2, and that has to do with your continuing education requirements. If you didn't do your 24 hours of CE, one of the alternatives was taking the brokerage administration course, which, as we were looking at that, it didn't really make sense that we make you take a class designed for people who are going to supervise brokers if you can't even complete your 24 hours of basic continuing education. Didn't make a whole lot of sense. So what we did was we designed a course. It's the broker reactivation course. It's to basically address the 24-hour deficiency issue, but also to address those brokers who have been inactive for a period of time that are looking to reactivate. And I know when I put mine on inactive status, it was like, woohoo, I don't have to worry about E&O, and I can get dumber by the moment while it's on inactive status. And I think some people do that. Fortunately, I get to work at the division, and I don't get to totally ignore real estate brokerage practice. But we wanted to design a course that would deal with the 24-hour deficiency, but also reactivation. So it's called the Broker Reactivation Course. It will be 24 hours of education that covers Colorado regulations, sales contracts, brokerage relationships, current real estate issues, and the current version of the commission update course. And you can use that in lieu of your 24 hours. You just can't do it consecutively if you're constantly on active status. The course goes into effect on January 1st of 2013. So if you're renewing right now and you took the brokerage admin course, you'll be fine. Just come after January 1st, what you need to do is take the reactivation course. One of the other rules that was recently revised was E1. It had a prohibition in there that you guys couldn't use credit unions for your trust accounts. In talking with the commissioner for the Division of Financial Services who regulates credit unions, they have the same safety controls in place as banks do as far as federal insurance. So we were able to make that change. So come November 30th, if you want to hold your trust accounts at a credit union, you will have that option available to you. One of the other things that we have going on, and I kind of mentioned this earlier, is we're back to doing continuing education audits of the real estate brokers. We do them quarterly. The goal is to basically throughout the year audit 10% of the active population. And I know that for whatever reason there's a rumor out there that we're trying to do all 37,000 brokers by next year. And I can tell you if that was our goal, I don't think I would have any staff doing CE audits. They would quit. But so right now with the recent audit, they did about 250 real estate brokers, found that 19% are non-compliant with the 24 hours of continuing education. Now, granted, that's a small little pool, but that is pretty consistent with the other audits we've done. We typically see that brokers, 15% or more, are non-compliant with CE. Now, to kind of give you an idea of where you rank with the other two key license types that we regulate, we've got the mortgage loan originators that really have been regulated since January 1st of 2007, and every year their laws have changed except for the past one. They are currently 10% non-compliant, doing pretty good for a newly regulated profession. The appraisers who have been regulated since '91, we have about a 9% non-compliance rate. And we help them with that because there's federal requirements that say if more than 10% of them are non-compliant, we have to change our process. So short of driving around, picking them up, driving them to class and teaching the classes, we pretty much make sure that we're hitting that 10% mark. So you guys have been regulated roughly since 1925. We would like to see a better compliance rate than 19%. So please do your 24 hours. I know one of the questions that was kind of sent over to me last Friday was, do we plan on increasing continuing education hours? And I can tell you that that would require a change in statute. And one of the things that we're looking at that we've been kind of mulling over are specialty license types. And I hate to say this word, for property managers. And now that they're talking about putting HOAs potentially under us, a lot of states regulate HOAs by having a broker's license, and I can tell you from what we see at the division level, simply having a broker's license I think is setting somebody up for failure if that's your only requirement for HOA regulation. So if we start looking down that road, we may start contemplating changing the CE requirements, and I think we also need to change the supervision requirements for brokers because we're seeing deficiencies in that area as well. So that's just kind of the current events that are going on. Now, we see some interesting things just kind of on a day-to-day business basis, and I can tell you, yesterday morning did not start the week off well because at 8:05 we get a call from a loan originator who's saying that he's dealing with a buyer's broker who has told him that there is nowhere in the contract documents or on the settlement statements that she has to document that her buyer is paying any closing costs. And basically, she kind of ended the conversation with the loan originator of, well, if you don't believe me, you can call down the commission and you can find out where it says in the regs that I have to do that. So he calls us, because we regulate them too, and we're happy to speak with them. And we quickly tell him it's Rule E5B that says that she needs to document what the buyer is paying. Makes us a little worried that it's not a good way to start off the Monday with the licensees. I can tell you that when investigators used to answer the phone calls, crazy stuff goes on over the weekend, both for the licensees and for the public. Having answered some of those calls, you know, we've got the brokers that call in and say, my listing burnt down over the weekend. Should I complete a vacant land listing contract? Back when we had those. That's awesome. The public would call in and say, my broker died over the weekend. Can I just go find a new broker now? So what's a little concerning is we have a broker out there that doesn't think that she needs to document what people are paying in the course of a transaction, and I'm really hoping that she has an employing broker that is attached to her hip at this point. We asked the loan originator for her name and also suggested that he file a complaint against her, but I don't think either one of those happened. Typically, when we start asking for names, that's when people hang up on us. 5 years ago, when we did the first kind of manual errors and omissions audit, and we had 9,000 brokers that were non-compliant with their errors and omissions insurance, we started to see brokers forging E&O policies, thinking that we don't know what Rice's policy looks like because they're only the state carrier, and we only see them every day. So, we wouldn't notice that there's strange shading on the forged document, or maybe the signature doesn't quite look right. So we had a couple the first year that did that. Yeah. So originally, the commission sought revocation of the license. They later negotiated down to, I think, about a $5,000 fine and a 6-month suspension for forging your E&O policy. And for the past 4 years, we've seen issues with every once in a while an E&O forgery crops up. So this year, I'm happy to say I am not aware of any E&O forgeries. What we're now seeing are CE forgeries, the certificates. So we had one broker from the Colorado Springs area, and I actually have a copy of the certificate, I believe. I don't think I took it out the other day. So just to give you an idea, you can make your own snazzy certificates if you want to, but this is what we issue when we do a course approval. And it's pretty standard. I think a lot of the education providers will just give this to you as well for your CE. So, but when we start seeing one that looks like this, and the interesting thing is the student and the instructor are married. We pick up on that too when they have the same last name. The interesting thing about this one is she claimed that she took this course down at the division, and we don't have very many courses that we have down at the division, and those are typically for staff, and they don't get CE for taking those because we all have to have inactive licenses, those of us that have broker's licenses. So like I said earlier, staff to some extent, if they wanted to take the attitude of the get dumber by the second because of no CE, potentially could do that. So she claimed that this was down at the division and that I was present. So I know what she's talking about, but her husband didn't teach this class. The Colorado Department of Health and Environment taught the class. He was just this strange person that appeared that made us kind of take note that never again would we invite this individual to kind of tag along and provide us his personal insight to issues with meth, which I think, I'm starting to wonder if he was a user. And so she claims that this happened in 2009. It was in 2007, so it's not even in her current audit cycle. She submitted 3 of these, one for 2009, 2010, and 2011, thinking that we would somehow forget hosting those classes annually, and that her husband was the instructor. So we had said, yeah, this ain't gonna fly. I can tell you my 8-year-old could do a better certificate than this. Her spelling might be a little off, but it would at least look a little more official. We kicked this back to her and said, no, this is not going to work. Your facts are way off. We do remember this course. It was taught by CDPHE. So then she submits some more documents, and we start to see the ones that look like our typical ones. And she submitted a student list. But the strange thing is that they were the same dates as this one. And she's from Colorado Springs. This is for a class in Berthoud. So we're like, okay, that's quite a drive. I live in Longmont. It feels like I'm almost driving to New Mexico when I drive down to Colorado Springs. So we started asking questions of the Berthoud provider, and the Berthoud provider gives us the student list, and guess whose name's not on the student list? So we went from a continuing education compliance issue, which, yeah, there's fines attached to that. She's now going over an enforcement for forgery, which falls under that dishonest dealing, unworthiness, and incompetency. And to even possess or obtain a broker's license, you have to demonstrate truthfulness, honesty, and good moral character. I don't think forging certificates like this really, support the standards that the commission originally looked at for licensure. They haven't seen it yet. I don't know what they're going to do with it, but the moral of the story is if you don't have it, just deal with not having it. With E&O, it's a $50 fee to reactivate your license, and you got to get E&O. Sorry, you got to have it to practice. It's a consumer protection measure. Plus, I mean, the nice thing about E&O, most of the policies out there, God forbid if somebody files a complaint with you, they provide you with legal representation when you have to deal with us. So there are some benefits, definite benefits for the brokers on E&O. With CE, if you don't have it, you don't have it. Don't forge the documents, because I can guarantee you the $250 fee or whatever she would have had to pay for her CE noncompliance is going to get blown out of the water probably by the fines. Fines, supervision, suspension, potential complete loss of income if they choose to revoke her license. So please do not commit forgery. I shouldn't have to say that. That falls under 1261-113-1M. I guess if we wanted to, we could file a police complaint. I don't know if we've really decided whether that's going to happen, but we'd prefer not to go that route. I've heard some rumors lately that are circulated in the broker community that we would like you all to have your own trust accounts, and I can tell you that that is not the case. If you don't have trust accounts, we love you for not having trust accounts, because then you can't have trust account issues. And for those that have trust accounts and maintain them in accordance to the rules, thank you for doing that as well. There are quite a few out there that don't. It's always an unpleasant thing to see somebody using other people's money, I don't know, to cover their overhead or their vacations. That pretty much puts you on the fast track to not being a real estate broker anymore. One of the other things we've heard about recently are improvement location certificates, and this is an issue that has come to us from the Department of Professions and Occupations. They regulate surveyors. There are two issues right now. This is a long-standing regulation that's been on the books, I think since the 1980s, like 1984. There's a statute under the surveyor license law that basically says that a buyer or a seller cannot order an ILC, which is problematic because that's not how most real estate transactions kind of go through the transaction. It's typically the buyer that's going to order the ILC. So they brought to our attention that issue. I don't know if they have any motivation to change that statute. I can tell you in the couple meetings that I've attended of the Surveyors Board, it doesn't really sound like it, but this is an issue. And we brought it to the Forms Committee, and the Forms Committee really didn't feel like they should have to change the contract to address this issue. So it is a lingering issue. The buyer and seller are not supposed to be ordering ILCs. And based on a conversation that we had about 2 weeks ago, I'm starting to wonder if ILCs are kind of going the way of the dinosaur. When you look at the title companies and also the lenders, what I'm hearing from both of those is that they are not using these very frequently. This is an infrequent requirement, so I'm not sure that that's necessarily something that we need to continue to have in the contract to buy and sell. I'm also worried that some brokers may be conveying that this is just like a survey, which it's not. So this is something that we'll kind of look at as we're going through the forms process. One of the other issues that we're seeing, though, or that we're hearing about with ILCs is there are some brokers, and this seems to be kind of geographic specific, so Boulder area is what I've heard, where they will go back to the seller and say, hey, when you purchased this 20 years ago and you got your ILC, could you just attest that nothing's changed? Not a good practice. We've noticed that people have issues with their memory even when they apply for a real estate broker's license. You know, we've had, well, and it's not just the brokers, it's the appraisers as well. We had an appraiser that forgot that he spent, time in prison for murdering his girlfriend. So if you can forget a prison term, chances are your seller can forget constructing a barn or maybe, an easement or whatever else may impact that property. So this is not a good practice, and I anticipate if we start seeing complaints about brokers doing this, that's going to fall under the unworthiness and incompetency, and depending on what advice they're giving, we may be needing to consult with the Supreme Court about the unauthorized practice of law as well. So please don't do that. A couple of the other things that we've heard are regarding broker commissions, and I can tell you we pretty much try to stay away from the broker commission issue as much as possible. Our concern is sign crossing, when a consumer is put in a position where maybe they've been abandoned, they sign up with a new broker, and the broker that abandoned them, once the transaction closes, is coming back looking for their commission, and a consumer is potentially in a bad spot, having to pay for the two commissions. That's pretty much, sign crossing is what we look at as far as your commissions are concerned. We do hear from time to time, though, that the front range brokers, should they go and transact real estate in the mountains, get cut out of commissions because they're not part of the local board. While we can sit there and you'll get a patient and sympathetic ear about it, or probably empathetic, there's really nothing that we can do, and we're not going to enter into that arena because those are your commissions that deals with things outside of our license law. What I have heard recently, though, is about commercial brokers, and the message delivered amongst the commercial brokers is I'm not going to show your property unless you up the commission that I get paid. Okay, well, that's where you're putting your needs in front of your clients. We are going to have a problem with that because that's a brokerage relationship issue. So if you're aware of that happening, you may want to give somebody a stern warning that this very well could become a commission issue. I know that we haven't seen any complaints about it because in the commercial arena, it's a small arena and they don't want to kind of rat each other out. But just be aware that if that's occurring and we catch wind of it, chances are, if we're able to substantiate the complaint, that's going to be a brokerage relationship violation. I don't know what the commission would do about that, but I mean, they're there to make sure consumers are protected, and if you're suddenly putting your needs above your clients, that's going to be a problem. So those are just kind of the day-to-day stuff that we see during the course of education audits, licensing. As far as complaints are concerned, we're seeing an increase in the complaints about brokers who don't provide the minimum requirements set forth in the license law, whether they're acting as a single agent or a transaction broker. Specifically, the MLS entry-only activities. You can't be an MLS-only broker. You have to provide all the duties under the license law, and that those are the only distinction is going to be whether you're a single agent or a transaction broker. So back in December 2010, we released the position statement to kind of clarify that. It's been a long-standing question. It comes up regularly over the 7 years that I've been with the division about, well, what's the minimum I can do? I'm always a little worried when somebody's just working at, like, hitting the minimum. That makes the industry really look good that, hey, hit the minimum and that's it. But so the minimum is what is outlined under single agency and transaction brokerage. But back in December of 2010, we had gotten a call from we'd gotten a call from a seller complaining because the Gunnison MLS would not make a modification to his listing. And Gunnison had told him that's an issue between you and your broker. Well, he called us to complain about Gunnison, and we started asking questions, and he had some really pleasant things to say about real estate brokers and how he felt about them. And we'd said, well, regardless of what you think about them, they have to do more than just put your property in the MLS. And we'd asked for, his broker's name, which he abruptly ended the phone call. So we called Gunnison, and Gunnison was nice enough to give us the name, and it was a Utah broker. And so as we went through the position statement and the adoption of the position statement, the commission gave the industry 3 months to come into compliance to make sure that their business practices complied with the license law. Well, Mr. Utah broker didn't do that. So here comes a complaint, and it's been within the past year. He's modified things a little bit, but he's still pretty much an entry-only broker. Recently, his case was heard by the commission in June. He had added some additional duties, which were pretty much the minimums, but you had to pay extra to get those minimums. Which, if you want to do a la carte services, hey, more power to you. We'll see what the consumer wants to pay. We don't care if you do a la carte or commission, but you have to provide the minimums. He also pretty much felt that with those brokerage relationship duties, he could just go through and sever whichever ones he didn't want to provide, which we came back and said, no. So it was his second bite at the apple. This time the commission decided, we'll give you a 60-day suspension, a $7,500 fine, and you obviously need to take coursework in brokerage relationships and contracts. And that's based on somebody who's got that business model. We have had a second one that has come up. He's also entry only, and he has been using outdated commission contracts, and this is a common theme that we see with the MLS entry-only brokers, is they're not using the current versions of the contracts. I'm frankly surprised that they even have any sort of contract document at this point. This broker actually had an addendum that was drafted by an attorney that put all of their minimum duties back on the seller. So, if you want to submit an offer, it goes to the seller, and it's then the seller's responsibility to get that offer over to the broker. The kind of the icing on the cake for us was that he had the requirement that with the closing documents and the settlement service or the settlement statements, he required the seller to get those to him after closing so that he could review them then. So the whole goal of having you guys review the settlement statements is that you do it before closing, so if there's any inaccuracies, they can be fixed before the person closes. The commission, once again, just basically said, this isn't going to fly. 60-day suspension, $7,500 fine, and you also need to take a class in brokerage relationships and contracts. Now, we recently saw a third case, and this broker does not have the MLS entry-only business model. He had decided, a one-time deal to help a friend out. He would do an MLS entry-only, charge the guy $299, and he didn't provide any of the brokerage services. And I think if any of you have ever heard me speak before, friends and family, we are like the first stop for them when you screw up their transaction. And it happens a lot. If we can work with the educators to kind of beat it out of their mind to market to friends and family, I think we might do that at some point, because friends and family are one of our leading sources of complaints. Compliments of his friends and family business, he's getting a $1,000 fine, and he'll have the public censure component. And the reason that they did that was just because he's not modeling his business practices after that, and when we brought it to his attention, he quickly brought it into compliance. So if you're seeing these minimum service brokers that aren't even doing the minimum services, they're just doing entry only, please let us know. You can file a complaint anonymously, but it's really our goal to address those issues to make sure that consumers are receiving the adequate services that they're supposed to receive under the license law. That, and I know it makes it extremely difficult when you're the buyer's broker and the seller has signed up with an entry-only broker, and they're nowhere to be found to help this person out. The buyer's broker gets to walk a very tenuous line of representing their buyer, but also trying to help this kind of disabled seller through a transaction because they're not understanding what's going on. So we're here to help you out on those. One of the other things that we saw this year is we had a national company that was providing marketing services and lead generation services to real estate brokers. And this complaint came to us from Division of Insurance. They had gotten a complaint from a title company. This firm was marketing to brokers, sign up for us for your marketing and your website and your lead generation. And you can sign up like a loan originator or a title company. We can use them to offset your website fees. And in some cases, we saw brokers that were actually profiting off of this little fee structure. The company was saying, we'll bill them directly, and that won't violate RESPA. Okay, well, I don't know how indirect billing somehow exonerates you from complying with RESPA. But what we also saw is the broker that did this started advertising in the MLS that, you've got to pre-qualify through this mortgage broker. And it's the mortgage broker who signed up to offset the marketing fee. And when we looked at the website, if a mortgage broker is paying half of your website fee, we would expect half of the website to be dedicated to advertising the mortgage broker services. And that's not what we saw. We'd see like this little link to the mortgage broker. So at the end of the day, it's a violation of E22, potentially a violation of RESPA. And if we see something like that, that is going to get referred on to the Consumer Finance Protection Bureau. And what we're looking at is if you're going to team up and do advertising with somebody else, make sure that the exposure that they're going to get is commensurate for what they're paying. If it's 50%, they should be getting 50% of the exposure. I can tell you we're not going to get down into the brain damage of how many clicks there are. A local attorney brought that up, and I said, yeah, I don't think we want to go there. But if you're aware of any of these services, I would avoid them like the plague. The commission gave the industry 3 months to come into compliance if you had one of these websites. That pretty much ended in September. So be very careful of those as well. A couple other things that we've been seeing is brokers that have acted as investors. We've had a couple brokers that have come in and basically said, I'll buy your property, and then they either assign the contract or it's an option, and they start negotiating on the behalf of the person that they've assigned the contract to. And brokerage relationships starts to get very messy and ugly. And in the cases that we've seen, there hasn't been any brokerage relationships established. We've had a couple of those that came up at the last commission meeting. One of the transactions, the broker came in and said, I'll buy your property. What do you think it's worth? And it was an elderly gentleman that was the potential seller. And he said, well, I paid about $185,000 for it 20 years ago. And it's in Denver. You would hope after 20 years, it's probably, increased in value from 185. The broker says, I'll buy it from you for 185. And he purports to be an expert in that area. He turns around and sells it for a profit, and the person that he assigned the contract to subdivided the property, sold the units off for a total of it was $600,000 plus as far as profit was concerned for those properties. Because of the issue with the brokerage relationships, the commission had a really thoughtful discussion about this. It's not their place to basically hinder your ability to make a profit when you're acting on your own behalf. However, when you're dealing with brokerage relationships, you need to bear in mind that you do have a competitive edge compared to Joe Public, who doesn't have a broker's license, on how real estate works, particularly if you're the neighborhood expert. They didn't choose to revoke that broker's license. However, he's actually looking at a downgrade. He's currently an employing broker. He'll have to be an employed broker. If I remember correctly, he's going to be facing suspension and a significant fine along with coursework. We had another one, though, that went to the commission, and he had listed the property. At some point during the transaction, they decide that he is going to do a licensee buyout. After he does the buyout agreement, though, there are offers coming in that he fails to present to the seller, and they were offers that were better than the buyout. He basically just said, no, my seller's not interested. He didn't have the authority to say that. It was a short sale property. The seller ends up with a deficiency in a tax liability. The broker is able to sell it for a profit. That one, they're seeking revocation on because it was a little more than blurring the lines of brokerage relationships. You've got to present all offers. It doesn't matter if you're one of the ones in line, you still have to present those offers. So those are a couple that we've seen. We're starting to see kind of a change from incompetent real estate practice to kind of premeditated criminal real estate practice, which, I don't know, I'm starting to enjoy the competent ones a little bit, or incompetent ones, rather than the more criminal ones. One of the other things that we see is disclosure of material facts, especially when you're selling your own property. We had a broker, and this went to the commission in June. He sold his own property. It had some structural issues. There had been 15 prior engineering reports done on the property since 2006. He had negotiated an agreement with the builder to go in and fix those. The builder was monitoring them. He didn't disclose the structural issues to the new buyer. So they move in, and lo and behold, they start seeing problems with the property. And they become aware from the builder that there's this 6-year history of issues with this property and that the builder was monitoring it. On that particular case, basically the commission decided that revocation was appropriate along with a $7,500 fine. So material facts, bear in mind, no matter how insignificant it is, they are going to find out after closing. And we had one yesterday who has only been in her condo for maybe a month now, and somebody tried to hide a mold problem, which is now raging out of control a month later after she closes. And we're working with her to try to figure out, is this a broker non-disclosure issue or a seller non-disclosure issue? So please, when you're dealing with the consumers, make sure that they fully understand that disclosure is in their best interest, because they can be sued afterwards if they didn't disclose something like that. We continue to see issues with transaction brokerage. That apparently just continues to elude people. I've heard brokers say, listen, if you don't want to sign a contract, that's fine. I can act the same way, whether you do or not. And that's not the case. When they sign a contract for you to be their single agent, you're their advocate. If you're a transaction broker, you're a facilitator. And some of the complaints that we typically see is when brokers decide to be transaction brokers for family members. I'm not really sure how you can be a transaction broker for your child. You need to be an advocate. We had one broker who I had a 30-minute argument with about how she could not be a transaction broker on the sale of her husband's property. Now, she's currently married. I guess if you're divorced, maybe you're a little closer to being a transaction broker, although I wouldn't recommend it because I would think you'd be like an anti-advocate at that point. Family and yourself are probably best dealt with as single agents, along with longstanding business partners. A lot of the time, the complaints that we see, the broker really should have been a single agent for those individuals as well. We continue to see issues with supervision, and that's why one of the things that we are just kind of evaluating is the need to increase the requirements to be a supervisor. Currently, you have to be active for 2 years, take the brokerage administration course, and then you can go out and employ other brokers. But there's no requirement on how many transactions you do in those 2 years, so you could actually do absolutely no business, go out and supervise, and do a completely terrible job of it. And we'd like to prevent that. We've heard some inquiries about whether the commission has considered issuing a position statement or something of that effect about brokers that use attorney-drafted provisions. And in some cases, it's viewed as the unauthorized practice of law. I can tell you that I don't think the commission is going to go down that road. That's kind of a standard practice for all of you and would impede your ability to draft the contract documents. I remember when I practiced 9 years ago, my brokerage had a provision that was drawn up by their attorney to address some of the property insurance issues that the brokers were seeing. We were aware of when that provision was acceptable to use, and so I doubt that you will see us take a position that by using those provisions you're somehow practicing law. But if that is a rumor floating out there, please give me a call so that I can try to put the kibosh on it. I will tell you, though, that we do see brokers that draft their own provisions, and that is a problem. That very well could take you down the fast path to unauthorized practice of law. You should not be drafting your own provisions. So please don't be doing that either. There was a question that was sent over from Melissa to me about competency and what we are seeing, and I can tell you just about every complaint that goes to the Real Estate Commission has a competency component. And we'd really like to get the message out that if you don't know how to do that transaction, don't do it, or find somebody else that can kind of mentor you through the process so that you can learn, but maybe there's two of you, a competent broker and you who's gaining competence, can go through and fulfill the consumer's needs. But I can tell you, competency continues to be an issue. I hear about, the southern part of the state would like to use real estate brokers to do PPOs for financing. That's not allowed under the license law. You have to have an appraiser's license to provide an opinion of value for basically a mortgage loan. We've also heard, about brokers brokering mortgages. That's not allowable now that loan originators are licensed, and this goes with seller financing as well. The sellers are exempted, the brokers are not. So if you're negotiating the terms of a residential mortgage loan, that requires a loan originator's license, and that is something that came about through federal law changes. So please keep that in mind. I can tell you that the Board of Mortgage Loan Originators, even when you're dealing with an assumption, feels that you should have a loan originator's license. And that's kind of their perspective of it. One of the other things that we're going to be dealing with, and we're actually going to be talking to the Board of Real Estate Appraisers about this at their November 1st meeting, is what we have been hearing a lot as you guys are trying to navigate through the inspection issues that you're seeing with the properties. What we hear from the loan originators and sometimes from the real estate brokers is that they are now using appraisers as property inspectors. That's not their job, and they are not qualified to do that. So please don't be using them as property inspectors. To some extent, when you're dealing with VA and FHA, they are aware of different requirements set by their clients, but by no means are they property inspectors. So we're going to be working with the Board of Real Estate Appraisers to address that issue so that that's abundantly clear to everybody. But just to give you an idea of some upcoming events that the division will be dealing with, appraisal management companies will start regulating those come July 1st of next year. Hopefully you will see your deals not get killed so often because they are hiring appraisers from areas of the state that don't know anything about the subject properties. We're going to be working on mortgage loan originator license reciprocity. They actually don't have it. We're also working on rule reviews for them. We do have an HOA information officer. He started last Monday. His name is Gary Kujowski. It might be familiar to all of you because he's done some teaching in the brokerage arena. And I anticipate that we're going to see a bill to probably regulate HOAs in 2013. Yeah. You guys are happy about that. I don't know that we are. One of the other things, we had an audit hearing for the Conservation Easement Program last week, and one of the things that the State Auditor's Office wants us to kind of evaluate is the potential for a pre-approval process for these tax donations. The afternoon of that hearing, one of the senators pulled a bill title, so we are scrambling at this point to look and see what other states are doing, because we have to go back in front of the audit committee in December, and there's potential that there's going to be legislation, unless somebody talks them out of it, in 2013 to totally kind of revamp the conservation easement process. We're also going to have 2 sunset bills going through the legislature. One will be for the Board of Mortgage Loan Originators. One will be for the Board of Real Estate Appraisers. I can tell you that there isn't anything earth-shattering with either of those sunset reviews. The appraisers, we will be losing the registered appraiser credential, and we'll be creating a new credential specific for tax assessors because the registered appraiser credential will be going away. But it looks like it's going to be a little bit of a busy legislative session for real estate come 2013.